a major law change in landlord-tenant law. It's Act 317, and essentially that is the fourth landlord omnibus law that we've had since 2012. And so the old law said that if the tenant claims a contest exists, essentially if they just say, I want a trial in front of the judge, that court commissioner had to grant that request, and it always went to the judge. The new law with Act 3117, what it says is that tenant has to raise valid legal defense before that they get the hearing in front of the judge. So now there's going to be a little bit more of the court commissioner deciding if a defense is raised or not before they automatically give it to the judge. In the past, a tenant didn't have to give a reason. They could say, I want a trial, I want a trial, and the court commissioner had to do it. Now, for example, if upon questioning it comes out that the reason the tenant wants the trial is because they lost their job and they don't have the money to pay the rent, that's not a valid legal defense. So arguably that court commissioner could deny the request for a trial in that situation under this new law. Abatement law was clarified, shall we say. What the law said is if the unit, the rental property, becomes untenable, a tenant could abate their rent for the portion of the unit that's untenable. They cannot abate 100% if they still reside in the unit. What was happening is some tenants were arguing abatement for very small things. So Act 317 clarified that you can only abate if the untenable situation is a life, health, safety issue, causes a dangerous condition, things similar to that, a larger issue. The statute prior to Act 317 said that if a unit is damaged because of the actions of a tenant or their guests or their family members, a landlord has a choice to either make the tenant do the repairs or the landlord can do the repairs and charge the cost to the tenant. Some courts were making a determination that if the landlord did the work themselves, that was not something that they could receive compensation for. So Act 317 clarifies that and actually says, as part of the definition of a reasonable cost that can be charged back to the tenant, it includes landlord's time, the materials that the landlord buys, and it is actually a little bit broader, not just the time making the repairs, but also the time purchasing the items, the materials, or calling a third-party vendor or contractor to do the work. So it includes that, so a landlord now has to be compensated for his or her time. A new section was added to 704 under Act 3117 dealing with waiver, and essentially says that it applies to both landlords and tenants and that their prior actions can't waive any requirements under the rental agreement or any other rental documents. And the example they give in there is failure to pay rent. Just because a landlord allowed the tenant not to pay rent 1 month doesn't mean that waives it for the future. But it goes both ways, so it can protect both landlords and tenants, but essentially you can't rely on that waiver defense. It's a really, really large law. The presentation that I did for the State Bar only dealt with the landlord-tenant law issues, and that would include things including notices and what kind of proof you have if you're going to send a notice via certified mail. That's changed. Notices, if you have an inaccurate amount in your notice, it still may be a valid notice that can move forward and be the basis for an eviction. Emergency assistance law was changed a little bit. It used to say that a stay had to be in place immediately. Now, certain situations, a stay can't be in place, and if it is, it's for a limited time period. There's a large section dealing with assistance animals, most notably emotional support animals, and it basically taking all of the law that's out there and putting it into the statute, so there's one place that a landlord, a tenant, a lawyer can go to access some of that information.